Many nations and peoples in our world today find themselves very concerned with a tiny sliver of land in the Middle East known as the West Bank. Over and over again, the charge is made that Jewish settlements in the West Bank are illegal according to international law. In this video and in the ones to follow, we will examine whether or not that claim is in fact accurate, and in so doing we will answer the legal question: is the West Bank occupied territory? We will restrict ourselves to the legal aspect of this question, not the multifaceted political sides, and we will base our presentation on the expert legal opinion of international legal expert Howard Grief, a native of the city of Montreal, graduate of the law school of McGill University, current resident of Jerusalem, and founder of the Office of Israeli Constitutional Law. His book, The Legal Foundation and Borders of Israel Under International Law, was published in 2008 by Mazo Publishers, Jerusalem. Our presentation will be divided into 7 sections, the most important of which is the first one, the International Legal Foundation, which will be dealt with in this video. Subsequent videos will cover the remainder of the presentation: Palestine during the Mandate, Palestine after the Mandate, the Palestinians, Israel undermining its own sovereignty, Judea, Samaria, and Gaza, and finally, what can be done today. So let us now begin with an examination of the International Legal Foundation. To understand the legal status of the West Bank, we must go back to the events that took place during and after World War I, when the foundational legal building blocks were put into place, building blocks that are necessary to answer our question. We will start with the Balfour Declaration. I shall make 3 points about this declaration. First, it was a non-binding, unilateral declaration which favored the establishment in Palestine of a national home for the Jewish people, and stated that His Majesty's government would use their best endeavors to facilitate it. Second, although it favored the creation in Palestine of a national home for the Jewish people, it stated that the civil and religious rights of existing non-Jewish communities would not be prejudiced. Clearly, therefore, the political rights of other communities could be prejudiced. Third, to make that point even clearer, the Balfour Declaration stated that the rights and political status enjoyed by Jews in other countries would not be prejudiced. So when considered as a whole, it is clear that the intent of the British government in 1917 was to create a Jewish nation and to give the Jewish people political rights in that nation to the exclusion of any other people. And finally, that nation would be known as Palestine. The Ottoman Empire ruled over the Middle East for hundreds of years before it was defeated during World War I. For example, it dominated Jerusalem for 400 years, from 1517 until 1917, when it was driven out by the British. This photograph shows the surrender of Jerusalem to British troops after the Battle of Jerusalem in December of 1917. But Great Britain was not the only nation that fought a war against the Ottoman Empire. There were 4 nations in total: Great Britain, France, Italy, and Japan. Contrary to a popular misconception, the United States of America never declared war on the Ottoman Empire. Now, since this group of 4 collectively defeated the Turks, the group of 4 collectively acquired sovereignty over the Middle East, including the portion of land that would become known as Palestine. Now, this is important to understand. The big question that the group of 4 asked themselves was, what should we do with this sovereignty? Unlike the behavior of most conquering nations, the Allies agreed not to retain sovereignty over the Middle East for themselves, which was their legal right under international law, but rather to set up a legal system to transfer sovereignty to the indigenous peoples of the area. This legal system would become known as the Mandate System. We will now explain briefly this Mandate System, where it came from, and what it was all about. Therefore, the next building block we need to put into place is a document known as the Smuts Resolution of January the 30th, 1919. Jan Christian Smuts was a South African statesman who served in the British government during World War I and was a member of Prime Minister David Lloyd George's war cabinet. David Lloyd George was the Prime Minister of Great Britain from 1916 until 1922. Smuts was a key negotiator at the Paris Peace Conference, the post-World War I conference that laid out the terms of the various peace treaties, and that formalized the mandate system in a memorandum that now bears his name. This memorandum, known as the Smuts Resolution, was also adopted at the conference. Two main points need to be made here. First, the Smuts Resolution was approved by the Supreme Council of Allied and Associated Powers. And in this case, since the United States of America was an associated power, the United States of America accepted the validity of the Smuts Resolution. And second, it is in this document that we first see international recognition that the Ottoman Empire officially relinquished its sovereignty to the principal Allied powers. Let us now map out a structure to help us understand how the territories of the defeated Ottoman Empire devolved after World War I. For the sake of completeness, although not directly related to our topic, is the territory that was known as the Hejaz. It was not a mandate because it was declared independent in 1916 during World War I by a local Arab ruler known as the Sharif of Mecca. We will mention him more in our second video. Three mandates were created from the ruins of the Ottoman Empire in the Middle East: Syria, Mesopotamia, and Palestine. France was responsible for Syria, while Great Britain was responsible for Mesopotamia and Palestine. Generally speaking, the Group of Four desired to transfer sovereignty over these mandated countries to the local peoples that constituted the majority in these countries, that is, the Arabs. However, Palestine would be the exception to the rule. Whereas sovereignty to Syria and Mesopotamia was earmarked for the local Arabs because they constituted the majority of the population in those areas, Palestine, on the other hand, was earmarked for the Jewish people, even though they did not yet constitute a majority of the local population in that country. Palestine was to be treated as a special case because of the conscious attempt by Great Britain to redress the wrong done to the Jewish people by the Romans 1900 years ago. Sovereignty in Palestine would not go to the majority population of the local inhabitants, but rather it would go to world Jewry as a whole. And finally, we show how these mandates and the Hejaz evolved into the nations we are more familiar with today. The green color represents Arab nations, the blue color, the single non-Arab nation. Now, during the Paris Peace Conference, the League of Nations was established with the lofty goal of preventing catastrophic wars in the future. The Covenant of the League of Nations, which was adopted on April 28, 1919, incorporated the mandate system as its Article number 22. This is an important milestone in the development of Jewish sovereignty over Palestine, as we will shortly see. But before we go any further, it is important for us to understand what a mandate is. In short, a mandate was defined in the League of Nations Covenant as a sacred trust. A sacred trust that had tutelage responsibilities upon those nations willing to accept it. In other words, a mandate was like an estate held in trust for a minor. The trustee does not have the right to use the estate for its own interests, and it does not have the right to divide the estate and give it to someone else who is not an heir. Rather, it has the sacred responsibility to administer the estate on behalf of the minor until the minor reaches the age of majority and is then legally capable of assuming direct control over the estate without the trustee's involvement. Finally, the Treaty of Versailles was signed on June 28, 1919. This treaty lays out the terms of peace between the Allied and Associated Powers and Germany. Although we are not focusing on the treaty itself here, we do need to note one important fact. The Treaty of Versailles incorporated the Covenant of the League of Nations as Part 1 of the treaty. And as we have already seen, the mandate system was included as Article 22 of that covenant. Therefore, the mandate system was recognized as international law and acknowledged as such in such important international treaties as the League of Nations Covenant and the Treaty of Versailles. So we now ask the question, how did the Balfour Declaration go from being a unilateral, non-binding resolution of the British government to a multilateral, legally binding document acknowledged in international law? Let us review what we have learned. First, we had the Smuts Resolution, adopted by the Supreme Council of Allied and Associated Powers at the end of World War I. This resolution outlining the mandate system was incorporated as Article 22 of the Covenant of the League of Nations. The entire League of Nations Covenant was included as Part 1 of the Treaty of Versailles. But the Balfour Declaration has not yet been made legally binding. That takes place when all of these documents come together into a single resolution known as the San Remo Resolution of April the 24th and 25th, 1920, so called because the conference was held in San Remo, Italy. The attending nations were the Group of Four, as mentioned already: France, Great Britain, Italy, and Japan. During the conference, however, the United States of America was added as an observer only. And as mentioned earlier, because the United States of America and the Ottoman Empire were never officially at war with each other, the United States was not a direct party of the San Remo Resolution at this point. The San Remo Resolution explicitly referenced the Balfour Declaration, and it made it legally binding. At this point in history, we see established the first multinational, international legal agreement affirming Jewish rights to all of Palestine. Let us now look at this resolution in more detail. In 1920, Lord Curzon wrote a letter to then Prime Minister of Great Britain, David Lloyd George, in which he wrote that the San Remo Resolution was the Magna Carta of Jewish sovereignty over Palestine, a direct reference to the actual Magna Carta signed in the year 1215 by King John, a document which outlined and guaranteed the rights and liberties of the English people. The San Remo Resolution was drawn up as a draft and as a final resolution over a 2-day period. At the end of the first day, 4 monumental legal events took place. First, Palestine was created as a nation. Second, Palestine was declared to be the Jewish national home. Third, sovereignty over Palestine was transferred to the Jewish people. And fourth, the Group of Four agreed to put into effect the Balfour Declaration. Now, discussions continued during the second day, and it was further decided that Great Britain would be the nation responsible for putting into effect the Balfour Declaration, and that it would become the mandatory for Palestine. Although Palestine's borders had not yet been defined, the Group of Four agreed that the intent was to recreate the borders that Israel had in the days of King David and King Solomon, including the borders that Israel had up until the time that the Second Temple was destroyed by the Romans in the year 70 of the Common Era. The biblical phrase used by David Lloyd George, which appears numerous times in the Bible, was "from Dan to Beersheba." It was not meant to be a literal definition, but a conceptual one. So we see that the legal foundation for Jewish sovereignty over Palestine was laid down between the years 1917 and 1920. A very important 2.5 years indeed. It must be stated that the existence of numerous Arab states on more than 95% of the Middle East is also a direct result of the San Remo Resolution. In other words, Syria, Iraq, and Lebanon, for example, are all legally justified in the modern world based on this very same international treaty, the San Remo Resolution. Let us now take a look at some international legal agreements that recognize the validity of the San Remo Resolution. First, we have the Treaty of Sèvres of 1920. Now, because this treaty was later superseded by the Treaty of Lausanne after the Turkish War of Independence, it hasn't been properly recognized by many today. Nevertheless, this treaty was an internationally valid treaty drawn up between the Allied powers and the Ottoman Empire, and it explicitly recognized the San Remo Resolution. Second, we have the Franco-British Boundary Convention of 1920, This treaty was drawn up between France and Great Britain in order to define the border between the mandated countries of Palestine and Syria. Third, we have the Mandate for Palestine itself of 1922, the legal constitution for Palestine. Fourth, the Anglo-American Convention of 1924 was a treaty that bound the United States of America to the terms of the San Remo Resolution, if you remember, having been excluded from having legal standing up until this point. As a result of this treaty, the United States of America became legally bound with Great Britain to the terms of the San Remo Resolution with respect to the Jewish people. And finally, we have the United Nations Charter of 1945. So how did the UN inherit the legal responsibility to protect and uphold the legal framework we've just laid out? The Covenant of the League of Nations, which incorporated the mandate system as already explained, laid the foundation for the San Remo Resolution. The San Remo Resolution, which incorporated the Balfour Declaration as already explained, laid the legal foundation and justification for the Mandate for Palestine. And it is this document, the Mandate for Palestine itself, which was preserved intact in the UN Charter under Article 80. So what does all of this mean for us today? First, it means that all Jewish rights under the mandate remain in full force today, including in particular the right to establish Jewish settlements in any part of the former mandated Palestine that is under effective Israeli control. And second, it means that no UN body or agency can legally prevent Jews from exercising their rights by interfering with those rights as defined in the mandate or transferring those rights to any non-Jewish entity. Article 80 directly states the following: nothing in this chapter shall be construed in or of itself to alter in any manner the rights whatsoever of any states or any peoples or the terms of existing international instruments to which members of the United Nations may respectively be parties. As you can see, it is no wonder that Article 80 of the UN Charter became known as the Jewish People's Clause. Let us now review the basic structure of the mandate and the transfer of sovereignty to the Jewish people that took place after World War I. Sovereignty over Palestine was transferred to the supreme Allied powers of World War I, those powers which defeated the Ottoman Empire, and this sovereignty was subsequently transferred to the Jewish people. This was accomplished between the years 1919, beginning with the Smuts Resolution, and 1923, when the Mandate for Palestine went into effect. Great Britain would serve as mandatory, acting as administrator, trustee, and tutor on behalf of the Jewish people, and the Council of the League of Nations would act as supervisor, ensuring that the mandatory executed its official responsibilities properly. In conclusion, we have established three significant pillars of Jewish sovereignty to Palestine under international law in the modern world. First, the principle of self-determination. This principle was enshrined in Article 22 of the Covenant of the League of Nations and the Treaty of Versailles, as mentioned already. Second, the Balfour Declaration, a document made legally binding as a result of the San Remo Resolution, wherein the Jewish people were declared to be the national beneficiary of the principle of self-determination in Palestine. And third, the historical connection of the Jewish people with Palestine, which answers the question why the mandate of Palestine should be different from all other mandates. In the second part of our presentation, we will examine the historical period of Palestine during the mandate years.
Many in the international community believe that the West Bank is illegally occupied by the State of Israel. In this 7-part series, we examine this assumption and will determine what international law has to say in this regard. In addition to relying on relevant legal precedents, treaties, and customary international law, beginning with the formative historic events of the early 20th century, our analysis is based on the authoritative legal treaties on the subject, the legal foundation and borders of Israel under international law by legal scholar Howard Grief. In part 1 of this video series, we outline the legal foundation in international law underpinning Jewish sovereign rights and legal title not only to what is called the West Bank, but also to all the land of Israel, known in the founding legal documents as Palestine. Now, in Part 2, we will briefly discuss the most important legal and political events that affected Palestine during the Mandate period. First, we will learn how the borders of the Jewish national home, that is, Palestine, were reduced, and second, we will learn about the catastrophic consequences of that reduction. One of the foundational legal documents we mentioned in Part 1 was the Franco-British Boundary Convention of December the 23rd, 1920. The importance of this treaty is that it defined the international border between Syria, Lebanon, and Palestine. In actuality, however, the government of France prevented the northern and northeastern borders of Palestine from realizing its proper dimensions as defined by the San Remo Resolution. The French wanted the water resources in the north to go to Syria and the Lebanon, not to Palestine. Beside the fact that this was the first illegal reduction in the borders of Palestine, there was something positive about it. For the very first time in international law, the borders of Palestine explicitly included territory east of the Jordan River. Before we bring up the next map, study this map closely so that you will be able to see what happened to the borders of Palestine between December 1920 and February 1922, when the demarcation agreement was signed between the British and the French. Shocking, isn't it? Not only were the Golan Heights stripped away from Palestine and illegally given to Syria and the Lebanon, but all of Palestine east of the Jordan River, which now became known as Trans-Jordan, was also torn away. How did this happen? First, the Council of the League of Nations illegally passed the British Trans-Jordan Memorandum on September the 16th, 1922, to allow for the so-called temporary separate administration of Transjordan from the rest of Palestine. And by the way, this was the first time the term Transjordan was used and given a separate legal distinction. We will explain more about how this took place when we explain the background to what led up to this egregious action, but for now, we should at least know that there were at least two fundamental events that contributed to it. The addition of a new article, Article 25, to the draft mandate in August 1921, and the signing of the infamous Churchill White Paper on June 3, 1922, limiting Jewish immigration to the territory of Palestine west of the Jordan River. Second, a boundary commission was set up by the French and British governments with the noble goal to trace on the spot the boundary laid down under the Franco-British Boundary Convention of December 1920. However, when the British and French surveyors walked the ground to demark the boundary, they changed the boundary. And on February the 3rd, 1922, this demarcation agreement was signed by both the British and French governments. However, for at least three reasons, it was illegal. First, the two countries were under a legal obligation, according to the San Remo Resolution, not to leave out of Palestine any territory, the so-called Dan to Beersheba formula, which we mentioned in the first video. Second, under the terms of the draft mandate that was being developed at that time, no territory of Palestine could legally be ceded to any other entity. And third, no modifications of the mandate could be made without the consent of the Council of the League of Nations, which in this specific case was not done. Let's now see the details of how Palestine had its borders reduced in so short a time, essentially between November 1920 and September 1923. The mandate for Palestine was approved by the British government in November 1920, and it was submitted to the Council of the League of Nations 1 month later in December. It could have been approved immediately, and if so, none of the border changes we've just outlined would have taken place. However, it wasn't approved by the Council of the League of Nations until July 1922, a year and a half later. Why was there such a delay? The governments of the United States and Italy both interfered in the approval process for their own self-interests. The U.S. government demanded to review all draft mandates due to corporate interests in exploiting petroleum and mineral resources in the Negev and the areas around the Dead Sea. And the Italian government pressed the French for assurances regarding its interests in southern Anatolia that might be prejudiced by the mandate for Syria and the Lebanon. Together, these actions created a delay in the approval process of the mandate that opened up a window of opportunity to change not only the mandate itself, but the borders of Palestine as well. Before we explain what took place during this year and a half, let's back up to set the stage. A monumentally important document had been signed as part of the Paris Peace Conference. On January 3rd, 1919, Emir Faisal, the third son of Hussein ibn Ali, the Grand Sheriff of Mecca, and Dr. Chaim Weizmann, who later became the president of the World Zionist Organization and eventually the first president of the State of Israel, co-signed what became known as the Weizmann-Faisal Agreement. This agreement explicitly stated that the two of them, as official representatives of the Jewish and Arab peoples, respectively, were mindful of the racial kinship and ancient bonds existing between them, and realizing that the surest means of working out the consummation of their national aspirations is through the closest possible collaboration in the development of the Arab state and Palestine. This quotation from the document proves that the Arab world knew and accepted that Palestine was being created after World War I to be the Jewish state in the Middle East. Further, in Article 3, it says, "All such measures shall be adopted as will afford the fullest guarantees for carrying into effect the British government's declaration of the 2nd of November 1917, which of course was the Balfour Declaration." Further, in Article 4 it says the following, "All necessary measures will be taken to encourage and stimulate immigration of Jews into Palestine on a large scale and as quickly as possible to settle Jewish immigrants upon the land." Now, as far as we know, this was the first and last time that an Arab leader publicly recognized the sovereign right of the Jewish state throughout all of Palestine. Now, we're able to answer the question of what happened between November 1920 and July 1922 that led to the changes in the mandate and in the borders of Palestine. In March 1920, Syria illegally declared independence and included Palestine in its declaration. And Faisal was proclaimed king of the Arab Kingdom of Syria. And this was after he had already signed the Weizmann-Faisal Agreement, agreeing to work with the Zionist organization to establish Palestine as the Jewish state in the Middle East. This declaration eventually led to war with France, and in July 1920, French forces removed Faisal's illegal government from Damascus. In response to his brother's defeat, Faisal's older brother, Abdullah, the second son of Hussein ibn Ali, invaded the area of Palestine east of the Jordan River, that's Trans-Jordan, from the Hejaz, threatened France, and in March 1921 entered Amman and unilaterally and illegally created a de facto Trans-Jordan government. It should be noted that both of these actions by Arab leaders constituted an Arab repudiation of the entire mandate system under which the Arabs were given Mesopotamia, Syria, and Lebanon. Not wanting to get into a fight with France, Churchill acquiesced to Abdullah's aggression and in the same month provisionally excluded Transjordan by making it a so-called Arab province of Palestine. The following month, the British made Abdullah administrator over eastern Palestine, Transjordan, and as stated earlier, in September 1922, the British government submitted a memorandum temporarily severing Transjordan from Palestine. To appease the Arabs even further and to justify the administrative separation of Transjordan to Abdullah in April 1921, the British government modified the draft mandate by adding a new article, which became known as Article 25. Article 25 states, "In the territories lying between the Jordan and the eastern boundary of Palestine as ultimately determined, the mandatory shall be entitled, with the consent of the Council of the League of Nations, to postpone or withhold application of such provisions of this mandate as he may consider inapplicable to the existing local conditions, and to make such provision for the administration of the territories as he may consider suitable to those conditions." First of all, it's worth noting that Article 25 acknowledges that the borders of Palestine actually do extend east of the Jordan River. Second, the British government did not have authority to permanently ignore key provisions of the mandate. This provision allowed for only a temporary suspension based on certain conditions. And third, these conditions were never specified. Now let's enumerate various articles of the mandate which Article 25 blatantly violated. It violated the second recital to establish the Jewish national home in Palestine. The third recital to recognize the historical connection of the Jewish people to Palestine. Article 2 to implement effective conditions to establish the Jewish national home. Article 4 to guarantee the Jewish agency's role in administering Palestine. Article 5, not to partition or cede Palestinian territory. Article 6, to facilitate Jewish immigration and settlement throughout Palestine. And Article 15, not to discriminate based on race, religion, or language. All of this smoke and mirrors led to the infamous Churchill White Paper, which we mentioned earlier, of June 3, 1922. In 1920, Herbert Samuel was appointed by British Prime Minister David Lloyd George to be the first High Commissioner of Palestine. And in 1921, Winston Churchill was appointed Colonial Secretary. Together, they redefined the Jewish national home in Palestine to mean a Jewish national home in part of Palestine. They changed the responsibility from establishing a Jewish commonwealth to developing only the cultural or spiritual life of the existing Jewish community. Zionist organizations would no longer share in the administration of Palestine. Transjordan would be excluded, and Jewish immigration in Western Palestine would be severely restricted. The British government's actions exhibited what is known in law as malfeasance, which is a hostile, aggressive action taken to injure the interests of the client, which in this case was the Jewish people. To make matters even worse, the British government exacerbated the problem by further illegal actions in 1928 and 1946. On September 16, 1922, the League Council illegally passed the British Transjordan Memorandum, allowing for the administrative separation of Transjordan from Palestine. And then, on February 20th, 1928, Great Britain signed the Anglo-Jordan Agreement, transferring administrative and legislative powers to Abdullah, violating the basic legal principle delegatus non potest delegare, meaning a delegate cannot delegate. Finally, on March the 22nd, 1946, after World War II was finished, Great Britain signed the Treaty of London with Transjordan, officially severing it from Palestine and acknowledging the sovereignty and independence of Transjordan, violating at least Article 22 of the Covenant of the League of Nations, the San Remo Resolution, Articles 2, 5, and 25 of the Mandate for Palestine, the Boundary Convention of 1920, the Anglo-American Convention of 1924, and Article 80 of the UN Charter. Before we conclude Part 2 of this video series, it should be pointed out that the British government's malfeasance toward the Jewish people had tremendous geopolitical repercussions, three of which we'll mention here. First, the attempted partitioning of Palestine, or the land of Israel, in 1947 by the nations of the world under the auspices of the United Nations, which we will discuss in future videos, would not have been so easily justified without these illegal precedents of the British government. Second, the Jewish state would have arisen much sooner than it did, and as a result, the Holocaust would not have been nearly as horrific as it was. In conclusion, we see that the Mandate period was fraught with tension and political intrigue that collectively worked against the Jewish people and against their sovereign rights in international law to the land of Israel, or Palestine, as it was then referred to in the international legal documents of the time. In Part 3 of this video series, we will focus on the important events that took place in Palestine after the Mandate period. Many in the international community today believe that the West Bank is illegally occupied by the State of Israel. In this 7-part series, we examine this assumption and will determine what international law has to say about it. In addition to relying on relevant legal precedents, treaties, and customary international law, beginning with the formative historic events of the early 20th century, our analysis is based on the authoritative legal treaties on the subject, The Legal Foundation and Borders of Israel Under International Law by legal scholar Howard Grief. In Part 2 of this video series, we discussed the most important legal and political events that affected Palestine during the Mandate period. Now, in Part 3, we will briefly discuss the most important legal and political events that affected Palestine after the Mandate period. We will discuss the attempt by the United Nations to divide Palestine even further to create another Arab state, this time west of the Jordan River, the results of the War of Independence and the Six-Day War, and the importance of the legal principle known as acquired legal rights, and its ramifications regarding Israel's sovereign right and legal title to the land of Israel, i.e. Palestine. Shortly before British rule during the Mandate period came to an end, on November the 29th, 1947, the United Nations General Assembly passed Resolution 181, recommending, not mandating or forcing, but recommending that Western Palestine be divided even further, essentially attempting to create separate Arab and Jewish states west of the Jordan River. However, the General Assembly did not then and does not now have jurisdiction under the United Nations Charter to change the legal status of Palestine. Why not? Because such an action would violate international law. It would violate, for example, the League of Nations Covenant, the San Remo Resolution, the Mandate for Palestine, the Franco-British Boundary Convention, the Anglo-American Convention, and the UN Charter itself. And even if Resolution 181 did not violate all of these treaties of international law, it still wouldn't be legally binding. Why not? Because the UN does not have the authority to create or diminish national sovereignty. It's as simple as that. For example, do you think that by a General Assembly resolution the UN can impose its will on, say, Canada, to demand that a portion of Canada's sovereign territory be lopped off and given to another nation, or used to create a new nation? Of course not. Such an idea is totally preposterous. Likewise, the UN did not then and doesn't now have the authority to do this with Palestine either. But we'll go even further. Even if Resolution 181 did not violate all of the treaties of international law we just referred to, and even if the UN General Assembly had the authority to create or nullify national sovereignty, there's actually a third reason why Resolution 181 has no further legal significance. Although it was initially accepted by the Jewish Agency out of duress, it was totally rejected by the Arabs through their coordinated act of war against the Jewish state. And in law, any contract agreed to by only one party, it's not legally binding. And further, force majeure, which is another common legal concept in contract law, frees a party from liability or obligation when extraordinary events or circumstances beyond its control take place. And since war is considered force majeure, even the sole party that initially agreed to the recommendation, that's the Jewish people, are not bound to their original acceptance of the resolution. Now, understanding all these principles, David Ben-Gurion, who was the first Prime Minister of the State of Israel, considered Resolution 181 a dead letter when he annexed land that the Israel Defense Forces had taken control of during the War of Independence, an action essentially undisputed by the nations of the world. What we see here are three maps. The one on the left represents the portion of Palestine that remained under British rule at the end of the Mandate. The middle one represents the proposed partitioning of that remaining portion by Resolution 181. And the one on the right represents the borders of the State of Israel at the end of the War of Independence. It's important to keep in mind that although we frequently see a map like the one in the middle, those borders never actually existed, and they were never mutually agreed upon by anybody. So contrary to the often spoken rhetoric, Israel didn't gain territory as a result of the War of Independence. It just didn't lose as much as it would have lost had the Arabs accepted the resolution and had they not attacked the Jews. The borders of Palestine, as laid out in the founding legal documents discussed in the first two videos, that should be the frame of reference, not UN Resolution 181. And so the question is, what happened to the legal framework for the existence of the Jewish state of Palestine after the War of Independence, considering the fact that the Jewish state was not in control of all of its national home by the end of the war? The answer is nothing. That's right, nothing. The legal framework remained completely intact. The scope of Jewish legal rights was not limited to the part of Palestine that became the State of Israel. All that happened was that the State of Israel did not have control over portions of the Jewish national home that it was entitled to under international law. Nations that recognized Jewish legal rights when the mandate was confirmed were just as bound after it ended. And that means that the countries that attacked Israel were all in violation of international law when they attempted to destroy the nation that actually held legal title of sovereignty to Palestine. Egypt and Iraq both affirmed the San Remo resolution when they approved the covenant of the League of Nations and joined the League of Nations. And Jordan, Lebanon, and Syria did the same when they joined the United Nations. And the so-called Green Line that we hear so much about in the news was not an international recognized border. It was just an armistice line. That's it. And further, Jordan, which, keep in mind, is an illegitimate nation that came into existence by the illegal actions of the Hashemite family and the British government, never gained valid legal rights and title of sovereignty over Judea, Samaria, and eastern portions of Jerusalem, what they called the West Bank. Why not? Because Jordan violated international law in attacking Israel in the first place. And Egypt never had legal sovereignty over Gaza, even though it actually never claimed it had legal sovereignty, but for the same reason. And Syria never had legal sovereignty either over the Golan Heights, again for the same reason. And all of this just demonstrates one important principle. A right does not arise from a wrong. Let us now jump ahead to 1967 and the Six-Day War. As a result of the Six-Day War, Israel came into possession of many areas of the Jewish national home: the Sinai Peninsula, the Gaza Strip, Judea and Samaria, the so-called West Bank, Jerusalem, and the Golan Heights. And the question here is, did Jewish legal rights and title of sovereignty to all of Palestine remain intact after May 15, 1948, when British rule under the Mandate ended, for the 19 years that those areas were occupied by Jordan, by Egypt, and by Syria? Article 70 of the Vienna Convention on the Law of Treaties declares a very important principle of existing international law. Unless the treaty otherwise provides or the parties otherwise agree, the termination of a treaty under its provisions, or in accordance with the present convention, does not affect any right, obligation, or legal situation of the parties created through the execution of the treaty prior to its termination. To put this into perspective, it means something very simple, that regardless of the war of aggression against the fledgling Jewish state and the subsequent occupation of parts of the national Jewish home by Syria, Jordan, and Egypt, the sovereign rights of the Jewish people over all of Palestine, including the West Bank, the Golan Heights, Trans-Jordan, Jerusalem, and so on, including the right to settle anywhere within Palestine, that's the land of Israel, without discrimination. None of those rights were terminated when British rule came to an end in May 1948. But the question lingers. Did the parties agree to terminate the rights of the Jewish people in the armistice agreements made between Israel and Egypt, Lebanon, Syria, and Jordan? The answer to that question is an unequivocal no. The parties did not agree to terminate the sovereign rights of the Jewish people to any of its homeland. So the Jewish people preserved their legal rights and title of sovereignty in the armistice agreements that Israel signed with Egypt, Syria, Jordan, and Lebanon in 1949. And among the international community, nearly every single country in the world, including all of the Arab states, did not even recognize Jordan's 1948 to 1967 illegitimate, illegal occupation of Jerusalem, Judea, or Samaria anyway. And to top it off even more, in 1988, King Hussein of Jordan publicly severed all legal and administrative ties that Jordan had with what he called the West Bank. So from the point of view of international law, all Jewish legal rights and title of sovereignty from the San Remo Resolution of 1920 remained intact even after the armistice agreements were signed after the War of Independence. And therefore, when the State of Israel captured the Sinai Peninsula, Gaza Strip, West Bank, Golan Heights, and the holy city of Jerusalem in 1967, it was merely taking control of territory that it was already legally entitled to under international law in the first place. In part 4 of this video series, we will examine the meaning of the term Palestinian and answer the question, who are the Palestinian people? Many in the international community believe that the West Bank is illegally occupied by the State of Israel. In this 7-part series, we examine this assumption and will determine what international law has to say about it. In addition to relying on relevant legal precedents, treaties, and customary international law, beginning with the formative historic events of the early 20th century, our analysis is based on the authoritative legal treaties on the subject, the legal foundation and borders of Israel under international law by legal scholar Howard Grief. In part 3 of this series, we discussed the most important legal and political events that took place after the Mandate period up to the end of the Six-Day War. Now, in part 4, we will briefly discuss the meaning of the term Palestinian. In the foundational legal documents of the era in which the Jewish sovereign legal title to the land of Israel or Palestine was being laid down, the question is, was the term Palestinian used, And if it was used, to whom did it refer? First, the Balfour Declaration of November 2nd, 1917. It declared that the Jewish national home should be established in Palestine. Second, Palestine was created in international law in the San Remo Resolution of April the 24th, 25th, 1920, to be the Jewish national home. Now, basic common sense would dictate that just as citizens of Canada are called Canadians, or citizens of Brazil are called Brazilians, the citizens of Palestine should be called Palestinians? But that would mean the Jews, right? But just so we don't rely on common sense, and since that sounds pretty bizarre, let's dig a little deeper. Article 129 of the Treaty of Sèvres of August 10, 1920, stated that Palestinian citizenship would be given to Jews who were resident of Palestine. Further, Article 126 of the same treaty allowed Arabs to move to countries which had an Arab majority and obtain citizenship there, but they weren't allowed to move to Palestine and obtain citizenship there. Why not? Because Palestine was earmarked for the Jewish people. But this really wasn't much of a problem for the Arabs, since there were many countries in which they could receive citizenship if they wanted, including the Hejaz, which later became Saudi Arabia, Syria and the Lebanon, and Mesopotamia, which eventually became Iraq. Further, Article 7 of the Mandate for Palestine of July the 24th, 1922, bound the British to facilitate the acquisition of Palestinian citizenship by Jews who take up their permanent residence in Palestine. And let's be clear, the Mandate for Palestine did not confer this right upon Arabs living outside of Palestine. So to summarize so far, Jews were allowed to immigrate to Palestine and become citizens, but Arabs were not. Now this may seem a little strange to our ears today, but it was pretty normal practice before 1948 to refer to Jews who lived in the land of Israel as Palestinians. For example, the Israel Philharmonic Orchestra of today used to be called the Palestine Philharmonic Orchestra. The Jerusalem Post of today used to be called the Palestine Post, and so on. So how did a name which was used in international law to refer to the Jewish national home become popularized as an Arab ethnic and national term? Historically, you probably already know that the term Palestine was the name given by the Romans to the ancient land of Israel in the year 136 of the Common Era to disconnect the Jewish people from their land. Unfortunately, almost 1800 years later, it was chosen to be the name of the country created by the principal Allied powers of World War I, to be the Jewish national home. But when the Jewish people declared independence, they changed the name of their country from Palestine to the State of Israel. And as a result, from 1948 onward, the term Palestine fell into disuse. And that would have been the end of the story had it not been for the PLO, the so-called Palestine Liberation Organization, a terrorist organization founded to destroy the Jewish state in Palestine. Essentially, it was they that hijacked the term Palestine and made it refer to a so-called homeland of the so-called Palestinian Arab people. To prove the point, Article 1 of the PLO Charter of May 28, 1964 states categorically, Palestine is the homeland of the Arab Palestinian people. Now this may be some sort of nice rhetoric, but it really has no standing in international law. Why not? Because it conflicts with international law. Article 2 correctly acknowledges that Palestine's borders during the period of the Mandate are the legitimate, indivisible borders of Palestine. That's good. And yet, the Charter then goes on and completely repudiates that very mandate in Article 20 when it states the following: the Balfour Declaration, the Mandate for Palestine, and everything that has been based on them are deemed null and void. Now how's that for being illogical? Further, Article 6 does not define when the Zionist invasion took place, but it clearly states that the term Palestinian is not a racial term, but rather a national one, because even they admit that Jews can be Palestinians. So let's focus on this last point a little further. The term Palestinian is technically both an anthropological or ethnological term to refer to a people, but it is also a legal term to refer to the individual, to a citizen. And under international law, both of these concepts coalesce together in the Jewish people. However, after Israel declared its independence, the term Palestinian fell into disuse, as we said earlier, but both in its ethnological and legal senses. What the Arabs did was to simply relabel the now abandoned term Palestinian and state that they are the Palestinians in both its ethnological and legal aspects. Not only that, but practically the entire international community has bought into this deception and now accept it as fact. It is exactly as Newt Gingrich said a number of years ago. He said, "I think that we've had an invented Palestinian people who are in fact Arabs, and who were historically part of the Arab community." Zohar Mohsin, former member of the executive committee of this so-called PLO, candidly admitted this deception when he stated the following in an interview on March 31st, 1977. "A Palestinian people does not exist. The establishment of a Palestinian state is just the means for continuing our struggle against Israel and for Arab unity. Since Golda Meir denies the existence of a Palestinian people, I claim that such a people does exist, and that there is a difference between it and the Jordanian people. However, in actual fact, there is no difference between Jordanians, Palestinians, Syrians, and Lebanese. We all belong to the Arab people. It is only for political reasons that we carefully stress our Palestinian identity, for it is in the national interest of the Arabs to encourage a separate Palestinian identity to counter Zionism. Yes, the existence of a separate Palestinian identity serves only tactical purposes." Now you may need to watch this video a second time simply because of the massive disinformation campaign and brainwashing that has been taking place throughout the world for the last 60 years. It is indeed correct that truth is often stranger than fiction. As Hitler wrote in Mein Kampf, "At first the claims of the propaganda were so impudent that people thought it insane. Later it got on people's nerves, and in the end it was believed." In part 5 of this video series, we will examine how the government of the State of Israel has undermined the sovereignty of the Jewish people over the land of Israel, that is, over Palestine. Many in the international community believe that the West Bank is illegally occupied by the State of Israel. In this 7-part series, we examine this assumption and determine what international law has to say about it. In addition to relying on relevant legal precedents, treaties, and customary international law, beginning with the formative historic events of the early 20th century, our analysis is based on the authoritative legal treaties on the subject, The Legal Foundation and Borders of Israel Under International Law by legal scholar Howard Grief. In part 4 of this video series, we discuss the meaning of the term Palestinian within the legal framework of international law, and the resulting total confusion that exists in the world today over the correct use of the term. Now, in part 5, we will expand this discussion while outlining some of the ways since 1967 in which the government of the State of Israel itself has undermined the sovereign legal title of the Jewish people to the land of Israel. Let's begin with a pretty simple question. where did the idea of occupied territories come from in the first place? After the War of Independence ended, the State of Israel acted in accordance with Israeli law, laws that we'll discuss in the next video, and annexed the areas of the Jewish national home that were held secure by the Israeli Defense Forces. This included Beersheba, Nazareth, Ramlah, Lod, Ashdod, Ashkelon, Eilat, and so on. Most of these areas were outside of what the UN General Assembly Resolution 181 in its illegal and illegitimate partition plan had intended for the Jewish state. Nevertheless, there was no massive outcry in the international community over Israel's annexation of these portions of its national home. Why not? Because the State of Israel acted in accordance with its own laws and annexed land that it held the legal sovereign title to according to international law. However, after the Six-Day War ended, which we discussed in the last video, the Israeli government ignored its own laws, the Law and Administration Ordinance, the Area of Jurisdiction and Powers Ordinance, and the Law of Return, and did not annex most of the areas of the Jewish national home held by the Israeli Defense Forces. Rather, the Gaza Strip, Judea, and Samaria, that is the West Bank, along with the Sinai Peninsula, remained under Israel's military rule. It's fundamentally important to understand that the failure to annex these areas of the national Jewish home gave the false impression to the world community and also to many Israeli citizens that they were occupied territories that didn't legally belong to the Jewish people. We'll speak more about this in Part 6, but in the meantime understand that they were not occupied territories under Israeli rule. Rather, they were repossessed parts of the Jewish national home that have not yet been annexed to the State of Israel. To follow up from what we demonstrated in Video 4 regarding the term Palestinian, 3 significant events took place after the Six-Day War that contributed to the emergence in the public consciousness of an Arab Palestinian people. The first was what we just mentioned in the previous slide. The fact that the Israeli government failed to annex Judea, Samaria, and Gaza. The second was the fact that as a result of the war in 1967, these areas of the Jewish national home were abruptly cut off from their previous 19-year-old Egyptian and Jordanian rule. And third was the advancement of Yasser Arafat as the leader of the so-called PLO in 1969. Simply put, it was the merging of these 3 historical developments that helped spread the false narrative of a so-called Palestinian Arab people. Before we see how the government of the State of Israel exacerbated this false narrative, we need to briefly trace the major developments in the international community's perspective regarding this so-called Palestinian Arab people. After the Six-Day War ended, the UN Security Council passed Resolution 242 on November 22, 1967. The resolution is interesting on a number of counts, and we won't take the time here to outline the numerous problems with the resolution. That's a separate study in and of itself. But rather, we will draw your attention to 2 rather positive points. First, the resolution recognized only a refugee problem, not a Palestinian refugee problem, not an Arab-Palestinian refugee problem, not even an Arab refugee problem, just a refugee problem. This wording was deliberate because it was also intended to convey recognition of the hundreds of thousands of Jews who had been made refugees by being exiled from the various Arab countries in which they had been previously resident. Second, the resolution was totally rejected by the so-called PLO because the resolution did not recognize a Palestinian people. However, by 1969, the political winds changed. In contradiction to international law, the UN General Assembly Resolution 2535 of December the 10th, 1969, explicitly referred to Palestinian Arab refugees as the people of Palestine and claimed the existence of inalienable rights of the people of Palestine. And by 1974, the UN had upped the ante on this false narrative with the UN General Assembly Resolution 3236 of November the 22nd, stating that this so-called Palestinian people had the right to self-determination, the right to national independence and sovereignty, and the inalienable right to return to their homes. But none of these so-called rights exist anywhere in any document of international law. And they don't exist because there's no such thing as a Palestinian people. They're just Arabs. And the Arabs were already given those rights, especially the right of self-determination, all throughout the Middle East, with the exception of the land of Israel, or Palestine. The Arabs have the right to national independence in Syria, in Lebanon, and Saudi Arabia, and so on, but they do not have that right within Palestine. But other than not annexing the territories of the national Jewish home that were under control of the Israeli Defense Forces, Israel made no positive action toward undermining its own sovereignty, at least not until 1978. As a result of the Camp David summit, representatives of the government of the State of Israel signed a framework for peace in the Middle East and a framework for the conclusion of a peace treaty between Israel and Egypt. In those documents, Israel recognized the so-called, quote, Palestinian people, end quote. Further, until 1994, Israel maintained a solid case in international law for exercising its sovereign legal rights over Trans-Jordan. With the signing of the peace treaty with Jordan, Israel, in violation of international law and in violation of the trust that was given to it by the Jewish people, recognized the territorial integrity, sovereignty, and political independence of Jordan over eastern Palestine. But the question should be asked, can the Jewish people who assigned their sovereign legal rights to the Israeli government in trust take action against the Israeli government for malfeasance? Time will tell. But without a dramatic shift in the internal politics of Jordan and Israel and possibly elsewhere, the Jewish people may not be able to do much about regaining their sovereign legal rights over Trans-Jordan. Once the Israeli government started to go down this road, matters went from bad to worse. In the infamous Declaration of Principle signed in Oslo in 1993, it officially recognized the PLO as the official representative of this fictitious Palestinian people and agreed to the illegal transfer of parts of the Jewish national home in the land of Israel to Arabs of the Palestinian Authority. And then in at least 3 separate agreements, the Interim Agreement of 1995, the Wye River Agreement of 1998, and the Sharm el-Sheikh Memorandum of 1999, Israel agreed to transfer its powers and responsibilities in Judea and Samaria, that's the West Bank, to the Palestinian Authority, accompanied by the redeployment of its military. For those of you who have watched this video series from Part 1 and internalized the facts of history relevant to the subject, it should now be more than obvious to you that the government of the State of Israel violated the sacred trust of the Jewish people to protect and take care of their sovereign legal territory, their national Jewish home. Besides these actions being a serious breach of sacred trust, the government of the State of Israel also violated Israeli law, and it should be asked whether in fact they also violated the law against treason. Subsection A of Article 97 of Israel's Penal Code states, "A person who, with intent to impair the sovereignty of the state, commits an act calculated to impair such sovereignty is liable to the death penalty or to imprisonment for life." And subsection B of that same law states, "A person who, with intent that any area be withdrawn from the sovereignty of the state or placed under the sovereignty of a foreign state, commits an act calculated to bring this about is liable to the death penalty or life imprisonment." Further, Article 100 states, "A person who does any act evincing one of the intentions referred to in sections 97, 98, 99 is liable to imprisonment for 10 years. Indeed, this is a very, very serious matter. In Part 6 of this video series, we'll focus our attention specifically on the West Bank, what has been historically referred to as Judea and Samaria.